Hello, good morning, depending on where you're joining us from. You're very welcome to our second Startup Canada Equal Slice webinar of 2025. This is all about protecting your intellectual property, a guide for equity-seeking entrepreneurs. I'm Isabel Nolan. I'm the Director of Programs at Startup Canada. Firstly, so sorry that we started a little bit later. We're having some technical issues on the background, so we had to restart. So I do apologize for starting a few minutes late. I would like to acknowledge the land on which I'm on today is located on the unceded and traditional territories of the Musqueam, Squamish, and Tsleil-Waututh Nations, also known as Vancouver. And as we're a national organization, I'd also like to acknowledge with respect the diverse histories and cultures of all Indigenous peoples on this land. I encourage you to take a moment to acknowledge the traditional territory that you're residing on today. Today's session is being recorded and we'll add it to our YouTube channel afterwards as a living resource. And we welcome you all to connect with each other in the chat as well. So please send in your messages introducing yourselves, any LinkedIn's or anything about your business as well. So Startup Canada and Pizza Hut have joined forces to empower entrepreneurs by providing them access to funding, educational webinars like this one, and business resources to help break down the systemic barriers. With the belief that everyone deserves an equal opportunity to succeed, the Startup Canada Equal Slice program offers pitch competitions, educational support, and tailored business tools to help entrepreneurs grow and scale their ventures. Before we get started, I'd like to give a massive thank you to Pizza Hut as well for their generous support of us in this 3-year partnership. And we may have someone from Pizza joining us later today to speak a little bit on their behalf on this partnership as well. Alrighty, so as I mentioned, today's webinar is focused on understanding the importance of intellectual property and learning how to safeguard your innovation or your innovative ideas and creations. Our 3 speakers today will cover IP concepts like trademarks, copyrights, patents, and specific guidance for entrepreneurs in equity-seeking groups as well. I think it's important for me to highlight that today's speakers are not lawyers, so they can certainly provide you with guidance and advice from their own experience, their own areas of expertise, and what they've seen in the entrepreneurial landscape. But the advice that they're providing today is general and isn't supposed to be specific legal advice for everyone. So we just wanted to be able to put that disclaimer out there for you. So just to give you an example, or rather a rundown of how today's session will go, each of our 3 speakers have organized a short presentation from their own backgrounds, talking a little bit about themselves and the organization that they're a part of, and why IP matters to them and their experience in dealing with it. So there'll be about 5 minutes each. And then we'll go into our panel discussion. We've got quite a few questions drafted out for our speakers today, just for us to ensure that there's a great flow to the conversation. But these questions are they're really more thought starters to open up the conversation for everyone. And it's really for you to be able to ask your questions as well. So if you have a question for today's speakers, you'll see that there's a Q&A box in the bottom function bar on your screen. So please feel free to answer or ask any questions. No question is too big or too small. Okay, so without further ado, I'm honored to introduce our speakers for today. So we have Alejandro, who is the co-founder at Bold New Edge, as well as a board member and treasurer at FORPIQ. We've got Caroline, Intellectual Property Manager for the Business Services branch at Innovation Science and Economic Development Canada, also ISED. And we have Monika, who is the Chief Technical Officer at Agapyo. I apologize, Agapyo.
Agapyo, yeah. Thank you.
Wonderful. That's my Irish accent making a mess
It's
of
perfect.
pronunciation.
You didn't make a mess of it. You made it memorable.
Thanks, Monika. All right, so they've each organized a quick little presentation for us. So I'm going to pass it over to Alejandro first to kick us off. So Alejandro, I'll give you a moment to share your screen.
Thank you very much, Isabel. Sharing my screen, just a second. I'm clicking on the button, but nothing is happening. So not sure if you are able to see my screen.
Let me just check here. You should have permissions to share your screen.
Okay, somehow it's not happening. So wondering if what would you suggest to do? Should
Great.
we continue
But
somebody
so,
else and then I'll come back?
yeah, so what I'll do is I'll go to Caroline and then Alejandro, if you'd like to email me the presentation, I can share on your behalf.
It is on the chat box, by the way, the presentation.
Okay, thank you. Caroline, I'll pass it over to you then to kick us off. Oh, and you just
Yes, I'm fine. Okay, perfect. I was just saving it on my desktop so I could actually share it with you guys. So I'm doing that as I speak. And then my mouse is having a bit of trouble. Okay, hold on. Okay, share screen. Can you see my presentation in a few seconds?
yeah, come
Okay, perfect. So I just hope I don't step on anyone. Can you see my presentation?
Yeah, it'll just need to go into presentation mode.
Okay, perfect.
Beautiful. There we go.
Super. With the hope that I don't step on Alejandro and Monica's turf, but I'm here to present intellectual property on the federal government perspective. So without any further ado, I work with the Canadian Intellectual Property Office, who is the federal government body that grants IP in Canada. So we receive applications on trademarks, patents, copyrights, and industrial designs. I am part of a team that's called IP Awareness and Education. We have the title of IP advisors, but we don't provide advice. We provide guidance, information. So pretty much our role is to inform innovators, business people, creators, artists, students, professors, pardon me, to understand IP, the strategic value. And we pretty much guide them by the hand until they're ready to file, leading them to meet with an IP agent or to file on their own. For free, we offer presentations, we offer one-on-one sessions, we do office hours, panels, events, trade shows, etc. Any occasion for us to meet with entrepreneurs or stakeholders and to raise awareness on IP. Shall I go into describing each of the IP rights, or you prefer to do it, Alejandro? I'm flexible.
I'd say you go ahead, Caroline, with
Okay, perfect. I'll do it very quick. Okay. I'll do it very quickly. When you talk about trademarks, patents, industrial designs, we are talking about national protection. So if you protect your IP rights in Canada, they're not protected anywhere else in the world. So you have to really build that IP strategy, where you're conducting business, where you're planning to conduct your activities, and then you establish your IP strategy. A trademark is valid in Canada for 10 years, renewable every 10 years, and it protects your branding. So a logo, a name, a tagline, a shape eventually, a color, a sound, etc. And again, so it's protecting you. It is providing you with an exclusive right to use that branding, and you can capitalize on that, monetize your trademark by granting licenses and even selling it at the end if it's the end of your project. Patent will protect your invention, your novelty for 20 years from the date of filing, and it's not renewable. And it protects a product, a composition of matter, a machine, a process, and it has to be new to the world or an improvement. So even if you're filing strictly in Canada, but the technology exists somewhere else in the world, you won't be able to patent it. You need to improve on it in order to obtain your patent. I'll jump into industrial design. To me, it's probably like the best kept secret when it comes to intellectual property. It's protecting the visual aspect. So what does your object looks like? The shape of a phone, the shape of an armchair, etc., etc. It has to be distinguished. It has to be distinguishable. Sorry, it has to be new, original. And in Canada, it's a 15-year protection. that could be transferred into a trademark under certain circumstances. Copyright, it's the only right that goes beyond borders, and it protects you for your life plus 70 years in Canada. Any original work ranging from pictures, photography, painting, source code, fiction book, choreography, lyrics, etc. And the last, not the least, trade secret, not protected at CIPO or any other IP office around the world. It's any information that's critical to your business, but it needs to remain confidential. A recipe, Coca-Cola being a good example. So there's no limit to the protection until someone discloses it, unfortunately. I'll skip those slides because I think we'll be talking about them later. So just so that you know, wherever you're based, we have an IP advisor covering that region. You can click on the QR code, access that form, and you'll be directed to one of us. We value our services and saying we provide you information. We're neutral, and we really target our conversation based on the business strategy. So what we do, as I say, we provide information, we help you understand IP, and we don't provide legal advice. We won't file your applications, and we will not recommend a specific IP professional. We have access to a list that everyone has access to, and we'll refer you to that list. So that concludes my short presentation, and I invite my colleagues, Alejandro or Monika, to join me.
Fantastic. Thank you so much, Caroline. And it's so useful for you to lay out you know, what each of those different components mean, and also like the time limit on it as well, right? Because I think you even see those big companies, like I remember Nespresso when they had theirs come out and then their patent all of a sudden ended, and then everyone was able to create their own version of that.
Exactly.
So, yeah, it's useful to know that sort of that structure. Alejandro, I'm going to pass it over to you, and I'm going to share my screen on your behalf, so you can kind of give me a little nudge.
It seems that I can share it now.
So I'll be able to. I'm sharing my screen for you.
Okay, that's good.
Brilliant.
Hello, everybody. My name is Alejandro Martinez-Ramos, and I'm based in Montreal. I am the co-founder of Bold New Edge, and also I am part of the board of administrators for FORPIQ, the Forum of the Intellectual Property in Quebec, but also the treasurer for this organization. So speaking about the FORPIQ, starting with how I'm involved with IP, it became because, for instance, I'm a marketer, I'm not a lawyer. So, but from the perspective that I've been working with a lot of startups for the past decade, working here with different organizations in Montreal, then I came across the relevance of IP. That's why I joined FORPIQ, because I understood that it was very important. So intellectual property, it means a competitive advantage in the global economy that we have now. Can we follow the next slide, please? So first, what is FORPIQ? FORPIQ is a non-for-profit organization established since 2001. And it became an observer member of the World Intellectual Property Organization in 2023. Our mission is to promote IP awareness, to educate also the change makers to leverage IP to generate more value. And the community that we serve are the business leader, corporations, SMBs, startups, intellectual property experts, investors, and government representatives. And we do so through conferences, forums, and webinars, as this one. Next one. Speaking about the intellectual property, as mentioned by Caroline, and just to simplify it, everything that you create that it involves your intellectual capacity and that is legally protected, that's intellectual property. And we can think of inventions such as new machine processes, literary and like literacy or other works. Like, for example, at Bold New Edge, we're building a program for training, and that's something that's considered intellectual property. The designs, the symbols. Next slide, please. We have different type of IP, which are already disclosed by Caroline. Next slide, please. I think that a good question to ask is like, why should an entrepreneur like myself, like yourself, care about IP? And I think that this is important. Most often we'll hear that he's speaking about the protection because it protects others from profiting from your business. Yes, that is true. But I think that I would like to highlight that this means to generate and secure value. And the value means money. So since the time that you're creating something, you're going to be able to profit from it. And you're going to prevent somebody else from generating revenues that belong to you, not to the other person, because this is the work that you put into this. And I like to see that this is the reason why you need to care about the IP. This is something I understood early when dealing with entrepreneurs, and now that I'm building my own organization. This is something that I need to care, because with this IP, as Caroline highlighted, you will be able first to commercialize your own product. Second, if you have like a second stream of product that you cannot profit because of whatever reason, because of your limitation that you have, the constraints in the market, but you can license it to somebody else that can bring you another stream of revenue that you can profit from. And also, the more IP that you have in your organization will help on building the value of your organization, of your startup. And at the same time, that is going to show, that is going to attract the investors that will be more willing to invest in your company, because your work is protected and because you have a means of commercializing and generating revenue for your company. Can we go to the next slide, please? So the IP, the value in perspective, worldwide, the intellectual property is worth calculated at 80 trillion US dollars worldwide, which is a huge amount of money. And that's only on intangible things. Most of it, such as the digital trade, for example, now that many of the things are becoming immaterialized, it grows at a rate of 24.5% per year, adding up to the $80 trillion per year. And just to give you some more examples, in the States, next slide, please. In the States, the digital trade regarding the IP, it is valued as $600 billion. Of course, most of it comes from the companies based in Silicon Valley, where they are having a tremendous impact through building on IP, on intellectual property. So next slide, please. So just to invite you, we have the next conference is going to be in November 26th. It is focused on how we can strengthen Canada's competitive advantage by leveraging IP. And this is a subject that we all need to care about, because it's not only about bringing the value to our companies, but also how to make the industries in Canada more strong, that at the end is going to have an impact on how our companies do here in the country. So this is the part that has to do with FORPIQ. Just to mention, if you just put the first slide of the next, please. I just want to speak a little bit about Bold New Age. Bold New Age is a not-for-profit organization. We are empowering leaders in organizations by leveraging exponential technologies. Next slide, please. We have a program that is called AI for Decision Makers in Advanced Manufacturing. So we are helping any person within the field of advanced manufacturing that makes decision to leverage AI. Through this program, which is hands-on on projects, the person that participates in this program will be able to build an AI roadmap and a project, and then later after, when finishing this, will have access to resources such as talent and funding. But one of the things that I wanted to highlight and how it relates to this subject is, first of all, 40% of the people that we are aiming to help with this program, we are aiming to bring them from underserved communities. The most focus is on women. That's the first part. Now, how it relates to the IP subject is we are helping organizations to come up with solutions that will adapt to their operations in order to optimize, and they can be more resilient and have more revenues. That said, throughout these exercises, they will be creating intellectual property that we are bringing a focus on, that later after they can be commercialized also through the network that we're building. So with this, and the invite you that I do for decision makers is we start in August. So if anyone is interested, just contact me. And that finished my presentation.
Fantastic. Thank you so much, Alejandro. I'll stop sharing for a moment. Yeah, if you can share exactly how you'd like people to get in contact with you if they're interested in participating in this, because of course this program is for underserved communities. I'm sure there are quite a few people here today that would love to learn more and see if it's
Yeah.
a thing.
People can contact me in my email address, which is down here, is in the chat box, alejandro@bolnewedge.com. And also I can inform you about the FORPIQ conference happening in November.
Fantastic. That'd be great. Thank you so much. And yeah, anything that we share in the chat as well, any sort of resources that are mentioned, we will put them together for you as well. But if you can also save the chat as well, and let us know if you have any difficulty in doing that. So for our final presentation, I'm going to pass it over to Monika, who is sort of our entrepreneur for the day, to speak about from that perspective. So for the attendees here today that are founders, Monika will really be able to give you a great perspective on what it's like to actually go through the process. So Monika.
Yeah, thank you very much, Isabel. I really appreciate the intro. I would say that Caroline and Alejandro are probably much better in terms of giving a broader perspective. My background is chemistry. I did a PhD in that. I've done 2 materials startups because of the chemistry background. And so really the only sort of experience I can give is how IP relates to a materials startup. So let's hope that I succeed with sharing my slides. Let me know how that's working for you.
Yes, looks good.
Excellent. Fantastic. So I think I may have mentioned context matters, and if I didn't, allow me to mention it now. Context will matter. I personally am not at all familiar with any sort of copyrights. I don't write books or do artistic works. That said, I have quite a number of things to say about patents and trade secrets. And so probably that's that's definitely going to be the fundamental basis of this discussion. Just to give you a bit of an understanding as to what the company does, I called it a materials company. That might not translate for everyone, so just really briefly, what Agapyo is looking to do is sell a brand new material that's looking to replace rigid plastic that is persistent in the environment. And we do this by using wood waste, which is the most common natural polymer that exists. We do a small little chemical transformation to it that allows it to melt instead of burning when you heat it. And that allows that new material, which we call jam, to be moldable in an industrial molding machine. And then at the end of life of that material, you can put it in your garden and use it as fertilizer. So you can perhaps start seeing how patents and trade secrets might become important, but how something like a copyright that would relate back to a literary work would not really be beneficial. Context matters in IP. So with that said, some of the lessons I've learned over the last, I don't want to say how many years because I haven't been counting, is the importance of the type of IP as it relates back to this kind of industry. So it's really important if you're in a materials startup and probably in a lot of entrepreneurship experiences to grow your moat. Basically, this is what your value proposition is and why you differentiate yourself from other companies or startups. IP allows you to do that. It gives you freedom to operate with legal exclusivity if you're using something like a patent, or just a bit of know-how that only exists to you if you're using something like a trade secret. Alejandro already mentioned that it is an important way to monetize your knowledge. Investors, if you're looking to find VC funds or even angel investors, during their due diligence, will look into how strong your IP portfolio, whether it's patents or trade secrets, is, because they will look at it as a signal for future potential revenue for in case of an exit or just through dividends. they basically look to your IP portfolio as a way of measuring how much money they expect you to be able to make in the course of your business. And then again, Alejandro did mention that IP can be used in licensing for a company like Agapyo. One way to look at this is we want to sell a new material onto the market. If we were to license this technique to other manufacturers, then potentially we can have revenue coming in without having to make any kilograms ourselves, making us very CapEx light. You can sell off entire manufacturing processes as a sort of manufacturing license, or you can sell off market segments that you yourself are not interested to go into. The other way of looking at the benefit of monetizing your IP is through an M&A transaction, where if you get acquired by another company, they will potentially add extra value to your final sale price, depending on how strong and robust your IP portfolio is. So there are lots of benefits to consider for an entrepreneur of this kind of an industry. That being said, there are also lots of challenges. Specifically in this case, if you are a materials startup and you're looking to patent significantly, if you're not careful, you might give away during your patent process. You have to disclose your technology. In that disclosure, if you do not have a way to police your knowledge, what that means is, say you have a process that gives you a competitive edge in terms of cost. If you don't have a way of measuring if somebody is infringing on your patent through some sort of a final product property, then you might lose your competitive edge by having disclosed that. So in this kind of an industry setting, it is really important to weigh the value of a patent versus the value of a trade secret. Lawyers generally have told me that if you can have a property of the product that you can measure through some sort of a technique that is unique to your technology, then a patent is worthwhile. If that does not exist, it is better to go with a trade secret. So just very briefly to summarize the differences between the two main IP possibilities that a materials company will probably look towards. Patents, which are well known, they do give you a lot of freedom to operate legally. They clearly state your ownership in a space, and you have the ability to monetize the potential of that patent. The disadvantages are that you have to disclose your technology in full for the patent to be defendable. Legal fees are very expensive, especially for startups, and it's hard to police certain patents. In those cases, you might want to go to trade secrets, where disclosure is not necessary. You do not have to pay for any legal fees. You don't have to worry about any trade secrets expiring unless, and this is the disadvantage, some of your coworkers, colleagues, or employees leak the information that is a trade secret. Here, if somebody else does reverse engineering on your material, there is no way for you to take them to court. They are not legally required not to infringe on your property. And it does require a significant amount of internal management of information in order to make sure that the trade secret is managed properly. So that's it for me. Thank you very much.
Fantastic. Thank you so much, Monika, for taking us through that. And I feel like you've each outlined so perfectly, the various different concepts and just how important it is. And there's even some things you're mentioning there that I wasn't aware of, and the, weighing out the options of whether to go with trade secrets or, with a patent. And I can also say, because we've done quite a lot of pitch competitions throughout the year, and even when we're doing pitch competitions, if there's someone's pitching a new innovation or a specific material, and they mention that they have either a patent pending or a patent, it really does kind of secure the judge's trust in the entrepreneur, as well as the longevity and knowing that that the business is going to be sustainable from that perspective as well.
Absolutely. Thank you.
Yeah. So to our attendees, this is now our time. We're going to go into our panel discussion. This is your time to ask your questions. So if there's anything that Monika, Alejandro, or Caroline talked about that piqued your interest, or maybe there's something that they mentioned that you feel is relative to your business, please don't be shy in asking your questions. As I said, you can ask it in the Q&A box. I might get started with a few of the questions that I had drafted out for the speakers, just to kind of warm everyone up and get us started. But I think all of you mentioned I suppose a con of patents and just protecting your IP is there is quite a lot of capital that's needed in terms of, the filing, maintaining, legal fees and all of that. So for entrepreneurs that maybe are in their early stages of their business, with limited capital, what are some of the most cost-effective initial steps, at least, that they can take in protecting their core IP without needing a full legal team from day one? Caroline, maybe I'll go to you first. You're on mute.
Sorry, I was distracted. I was answering an answer. I was answering questions. So could you just shortly repeat, please?
No worries. Yeah, and no, don't worry about answering the questions as well. We can ask them live as well on there. But thank you so much for answering those two questions. That's brilliant. So in terms of for entrepreneurs who have limited capital, what's the most effective initial steps that they can take to protecting their IP?
Okay, first I would say learn as much as possible from free resources. It goes back to I'll be promoting SIPO, but we provide neutral information guiding you to meet with an IP agent. So we'll help you to do as much research as possible. You'll understand. So when you meet with your IP agent, be it a patent agent or a trademark agent, you've done most of the research that's necessary for them to make a legal information as to, yes, we should file for patent. Yes, we should file for trademark. Like, do as much research. Like when we talk about novelty, often enough I get people saying, "Oh, I've invented the best thing in the world. Have you done your research?" No. I know it's new. I know it does not exist. I know it's the best. Well, do your research. Make sure that what you have developed is new, is useful, and is ingenious, and then go ahead with thinking of patent, but do your research.
That's such great advice. And I think also in doing your own research, you're educating yourself on it as well. And I think that that's also important for you to understand the different
and rely on your network. You, as an entrepreneur, as a business person, you do have a network of advisors, of economic development agent. Maybe you have contacts at the federal, provincial, regional level with other entrepreneurs. Learn from them. Get as much information as possible.
Yeah, excellent. And that's why we're here. We're hopefully providing you some information that you can use us as your network as well. Thank you, Caroline. Monika, what was it like for you when you were starting out and maybe you had some limited capital?
Yeah, so great question. I think that having a patent in hand is going to be really important to build trust with any pre-seed investors or any sort of agencies that might be looking to provide you with more capital. So I think there is value in targeting good IP through a patent early on. What I would like to say, and what it took me a while to understand, is that it's not necessarily a new item that can be patented. Rather, the terminology that lawyers always used with me was, is it non-obvious? You can have something that's brand new, but if it's obvious to an expert in the field, it will not pass patent. So it's really important, I think Caroline is right, to really dig into your network, be humble about the technology that you have, the innovation that you have, and really dig down deep into, does it pass the non-obvious test? And then the last thing that I would say is while you're doing all of that, trade secrets are free. So the important thing for a patent is that it not be disclosed. What that means is feel comfortable using a non-disclosure agreement between whoever you talk to about your innovation or technology. If you mention it to someone without an NDA, it is considered disclosure and it is no longer patentable. So be really careful about who you mention your technology, who you talk about your technology with, if you want to at some point patent it in the future.
Excellent. Thank you so much, Monika. And Caroline, I can see you're answering some questions. I appreciate it so much, but I'm actually gonna bring them up
Okay,
verbally
perfect.
because I think that the questions that some people are asking are
Mm.
brilliant. And I think that a lot of people can benefit from them. But I appreciate you answering them typed as well. Alejandro, I don't know if you have anything additional to add to that when it comes to having limited capital and what you can do on your own time or your own efforts before you're bringing in the big guns.
Sure, I do. Actually, what Caroline and Monica highlighted is extremely important. Educate yourself. And educate yourself, I would highlight it again, is because when I started from zero, is I didn't even realize that I was already creating some intellectual property. And I was creating some intellectual property. But since I didn't know what it was exactly,
Mm.
who knows, right? So I might have lost hundreds of thousands of dollars down there on my journey. So, but besides that, once you start educating yourself, I think that what it costs almost like nothing is the planning. You need to sit and you need to see what you're doing. And every single step of the way of your journey when you're creating the product, you need to map it out where you are creating the intellectual property, because that is well going to allow you to know where to pay closer attention and be more careful when protecting. And with protecting, we're talking that you need to keep contracts that you will have to have contracts with your employees, for example, and you have to disclose things with your employees. So you need to have in consideration that those contracts have already an NDA. And those are going to be some first steps that probably when you're working with a team and you're discussing things on the go, on the heat of the conversations, there are things that are going on and you are not protected. Those are things that perhaps you already worked on an NDA for any other reason. Well, you already have the way how to protect yourself without adding an extra layer of money to put that there. And one of the other things that I learned on the planning is that to document everything that you're working on, you need to document it. So that is not going to take you more money, just time. Because having the reflex that, okay, this is what I'm doing right now. It is intellectual property that I'm creating. And although I'm not having access to a lawyer right now, I'm documenting it. And by documenting it, I will have a way how to prove it that is mine. And of course, you'll have to keep your files up to date, and you will have them to have them in a secure place where you can digitally speaking. Well, there's ways to implement it at a low cost. So those are the things that I could add to this.
Excellent piece of advice on the documenting everything as well, right? Like that's not going to cost you anything. You just need to be diligent about it. All right, we've got some really great questions coming in from our attendees. And we do have some typed answers, but I think just again to reiterate them because there's a few people that are asking questions that I think would be great. Claudia asked that they would like to know the prices and if there's funding or grants available for it. And Caroline, I know you said you can help with this. Can you just expand on that in terms of what
Absolutely.
support?
Okay. First, depends on where you live, but federal government offers plenty, well, I won't say plenty, but some options for funding innovation and IP. So you can look into Innovation Canada and you can talk with an agent and they will guide you to the right resource. On your provincial side, I would say reach out to your economic development innovation department, whichever the name could be. If you're based in Vancouver, again, I'm not familiar with everything that happens in BC, but I would say there's a lot of also incubators and accelerators that would be able to help you. I mean, BDC comes to mind, as I say, Innovation Canada, maybe look also at Pacific Canada, the Federal Regional Development Agency. If you want to look into cost, I will do what SIPO charges and what the cost would be if you hire an agent. So let's start with copyrights. You file on your own online in $63. That's one shot deal. Trademarks will start at $430 with variations if you add, and I won't go into the technical details, but let's say it started at $430. If you add the cost of a trademark agent, you're looking at $1,500, $2,000, $2,500 per trademark, depending on the complexity and the role of your trademark agent. Patent, if you look at SIPO fees over 20 years, because you've got annual fees to maintain, it's $3,000 to $4,000 over 20 years. When you add the cost of a patent agent, you're looking at $15,000 to $20,000 per country, and maybe Monika can confirm or say it was more expensive. It really depends on also the patent agent you hire. Internal design, sorry, is around $700 to apply, and is the cost of the fees of a patent agent also. So you add that. I think I've covered them all. Trade secrets obviously are free, or they're like the lawyer you hire to write your application. Alejandro, you may want, yes, please.
I just wanted to add, well, it is not a direct answer to the question that I was raised, but I just wanted to highlight that there are some programs that are offered that I believe they are financed by the federal government, such as Elevate IP, right? I'm just putting the link here in the web chat.
Perfect.
This is a program that pays for educate, but it doesn't pay you for educating you, but they have a means to have you educated into everything that's regarding the IP, and they also have the means to pay for certain fees related to IP. And I believe that there are programs that are focused per region, perhaps. Maine, for example, the one that I put here, perhaps is more focused on Quebec and anything that is based in this area. But I believe that there are other organizations across the country that are also part of this program. You might have more information.
Actually, Alejandro, thank you so much. Elevate IP, if you're in Atlantic, it's Springboard Atlantic. Quebec is Maine. Ontario and Manitoba is Communitech. Elevate IP Alberta. And then I think it's New Ventures BC in Pacific. But yeah, they can help you, depending on how they work, they can help you even to fund your IP strategy. Good point. But that will all be filtered by Innovation Canada if you reach someone at Innovation. Absolutely.
Excellent. Thank you. I'm just making a note of those resources. Monika, do you have anything to add to that when it came to, the costs and what it came down to for your business?
Yeah, so most of the costs are legal for a lawyer, and that'll depend upon how expensive the firm is, how senior the lawyer themselves is, whether you're using the lawyer or an agent. What I would say is that you can break up the patent cost. You don't have to go straight directly to a patent. Oftentimes, at least in the chemical fields, you start off with a provisional, which provides you with quite a bit of trade security as well, trade secrecy as well, while also getting a disclosure date. So you can benefit from both sides of the coin, and that's generally been preferred in the situations I've been in, so I have a natural bias towards it now. The other thing I would say is, depending on how good your language skills are, you can offset some of the legal writing costs by doing a really good first draft for the lawyer, so that when they see it to draft the actual patent, they don't have to get back to you with lots of questions of what is it that you're trying to do again? So diagrams are really helpful. Descriptions are really helpful. By descriptive, I mean really going through the details, explaining exactly what the non-obvious aspect of your innovation is really important, and providing them with an understanding and background of what already exists, either in the literature, the scientific literature, or patent literature. so that they build that understanding as opposed to having to use their billable hours on that.
Brilliant, brilliant piece of advice there. All right, we're getting so many questions. I'm delighted because we never know what the attendees will be asking or how much questions they'll be asking. So thank you all so much for submitting your questions. I'm going to go through them one by one as they've come in. If there's anything that's a repeat question, I may just skip that. So Sarah Bolton is asking, can you touch on the current general rules and regulations around AI properties? So content and or images that is created. Any of our speakers have thoughts on this? I know Monika, no.
Alejandro, I can start.
Yeah.
Unless you're burning to answer that question.
Well, if you have something to add, Carolyn, feel free to add it. I believe that there is more relevance now to highlight on digital space that is not only related to AI per se and everything that has to do with data. Doing my research right now, I'm working on building things that are very related to AI. I'm still working on seizing all the details that I had to work on in order to secure the IP from that. What I have learned so far is that think about in a portfolio approach, not only thinking on just in a specific, like, going directly to patents, but going layer by layer, thinking about the algorithms, thinking about the data that I have collected ourselves through the operations or that my customer will have through their years of operation, but also on the data that they will be creating, perhaps with the new data sets that are being artificially created. Those things that I also could be think of a layer and the platform designed to they have the sharing of this data to specific levels of organizations.
Absolutely. And what I can add is that typically any IP rights have to be granted or registered have to be generated by humans. And if you think of, let's say the Patent Act was created, I think in 1920 something. So obviously AI was not in anybody's mind, but I would say something that we always say when we talk about IP is like, it depends. So if, let's say, I'll try to find a really concrete example, but let's say you're asking an AI to say, write a fiction book that's got character Paul and Susan and David, and then they live in Ottawa and they do this and they do that. Your contribution is maximized, as opposed to say, write me a fiction book that sets place in 1925. Then AI would be the creator. So it really depends. It's a case by case. And it's always because it's such a new area, there's not much jurisprudence in it. So it's hard to make a decision, and to raise awareness, it's even difficult because we're swimming in unclear, I just say muddy waters. It's very new, so we'll see as we go. But there's always, I mean, you can talk to specialists, you can talk to IP agents, you can talk to us. We're not specialists, but we have an idea, and you can reach out to your community and ask people what they've done and what was the result. And Alejandro, please keep going.
I'll just I think Monika, do you have something to add to the conversation? Please go ahead.
Well, I actually have a question from the perspective of your own personal IP and AI like ChatGPT. My understanding is that if you're using a public instance of ChatGPT and you're putting IP in, that would be considered disclosure. So my understanding, and perhaps do correct me if I'm wrong, you need to be careful with how you use AI and especially around anything that you do want to keep a secret or you do want to patent in the future.
It's a really great point. Yeah, absolutely. It's a public domain, and you don't want to be disclosing anything. So that is very very important to highlight. Alejandro.
Yeah, indeed. It raised a question for me as well. Now, if you allow me, although I'm a panelist to answer questions, but here I have a question, and it's more of a brainstorming with my colleagues here around the table, not to put anyone under the spot. But when creating, and as Caroline highlighted, AI is so new. There are still many things that are working on the side of on policy and laws and everything in order to put a framework for how people work and collaborate with the AI. It is very new, we don't know. But for example, in the case of AI, there are so many things that I'm using it not for getting the answers, just to refine my thinking. That it includes a lot of my thinking when I inputting everything into the AI, but with my help, then I could come up with a very sophisticated way of methodology of doing things that are being based into my interaction with AI. So I wonder if that would be patentable, right? Because we know that if it is created uniquely by the response that gave me ChatGPT or any other tool, it is not, because it is not human intervention. But then on the other setting is like, yes, there's a lot of human interaction there, because and maybe many will disagree with me, but AI is still not as AI is still not as intelligent. I mean, it cannot replace a human thinking into many aspects. It requires a human, and a human can be a superhuman with the help of the AI. So I think for me, that would say, and once again, I'm highlighting, I'm not a lawyer. I'm just speaking out of my own experience. But I would say this is something that could be patentable, perhaps.
And it's a great point. But I also wonder, and to Claudia's point, as they've followed up as well, what if, the core structure of your business is an AI model that you have created? How would you go about patenting that or protecting that in that case?
I can start with some answers, and please correct me, but to me, if you patent anything that's software related or AI, you have to remember that when you file for patent, it takes most of the time a few years to get patented, and chances are the AI, the code itself, will be changing almost daily or monthly or weekly. So when let's say you file today for a patent when it comes to AI and software, in 6 months your software is completely different. So you have to apply for patent again, because it's obsolete exactly. So depending on it may be protected by copyright, yes, for sure, but filing for patents may not. It could, if some elements are much more permanent. But in a few months, most of the time, you've changed it. It has evolved. It's faster. Whatever it is, there's new functionalities that were added. So that's one of the elements you may want to think about. But Monika, do you have any insight on this?
Well, so again, it's not really my background, so I don't necessarily quote me on this, but my understanding is that for code, it's more of copyright.
It's copyright, yes.
Patent. I would imagine, because for a patent you need non-obviousness, I think you'd need to have a non-obvious new innovation of coding for that to be patentable, in which case it's a completely different field. I think for code, anything that's written usually falls under copyright.
Copyright, exactly. And I'll do some, I'll build up on this. Is, let's say you protect your code by copyright. It's the code itself that's protected. It's the language. So anyone else can develop a similar software using a different code. It's just that you can't copy the code. If you manage to patent part of your code, then that functionality is protected. One example that comes to mind, it's an old one, but when Amazon filed for patent protection for their one-click, it finally was protected in Canada as a patent, but it was only that small portion of the entire code that was protected. And I saw, building on that, someone said, what about patenting the idea? You can't patent the idea. You patent how the idea is generated. Is it a code? Is it a product? Is it, a composition? So you don't protect the idea itself.
Wonderful. Thank you so much, Claudia. I hope that answers your question. And if there's anything you'd like to follow up with, please let me know, and I can point you in the right direction to one of our speakers. So FundMe is asking, what grants and loans are available from government to help with IP legal costs? Are there any? I know you've kind of mentioned like Innovation Canada and the various different regional supports that are out there, but are there any grants that would help specifically with legal costs? or not
actually,
other avenues that maybe FORPIQ could go down?
I'm thinking of something. There's a program at the federal called the Small Business Financing Program, and it's with Canadian banks, and entrepreneurs, innovators can get a loan that's guaranteed by that program. And it's, as of 2 years ago, IP expenses could be covered.
Mm.
So, and your bank, you can talk to your banker and to your financial advisor, however you call them, and they may not promote it, but it's a program that exists. Again, at the federal, yes, Innovation Canada Innovation Canada, we have innovation officers or advisors, sorry, and they will guide you through different sources of funding from regional to federal, because it varies from one region to the other also.
Yeah. Cool. So when we get in contact with ISED, and they'll point you in that direction.
Exactly.
Sarah from Toronto is asking, when you say obvious testing, what exactly do you mean? So maybe that was something that one of you mentioned before. Monika, maybe?
Non-obvious. Yeah, it's not obvious what that means, which is ironic. And it takes a little while. I required a couple of lawyers to explain it to me from their point of view. So fundamentally, what it means is if you ask someone that's technical and knowledgeable in the field, whether your discovery, if they can think through your discovery and get to your discovery without having done any of the work that you did to get to whatever innovation you are trying to patent, then it will likely not pass the non-obvious test. Now, it is subjective what somebody finds non-obvious. There is a bit of I feel like this is non-obvious versus another person thinking, well, I didn't know it, so it's not obvious. And so sometimes you'll see patents where you look at it and you think, well, they got a little lucky there. But fundamentally, it is if you're the expert in the field, you were surprised by the discovery when you discovered it, or when somebody explained it to you.
And if I can add to that, I kind of call it the wow factor. Someone who's versed in the field would say, I should have thought of this, And if you go back to the 3 criteria, novelty, usefulness, and ingenuity, after speaking with a lot of patent agents and examiners, novelty, I would say, is fairly easy to demonstrate. Does it exist or not? You have proofs. Usefulness is also fairly easy, but ingenuity is where most of negotiation will reside between your examiner and the agent, because one will argue A, one will argue B and C and D. So, and at the end of the day, they agree on what is new, what is useful, what is ingenious in the patent application.
Thank you so much. Great question, Sarah. All right. So FORPIQ is interested in learning more about copyright. So they said they have educational materials, for example, a curriculum of a teaching workshop that they're creating with third parties. So how do they go about securing copyright for what they do? And maybe also we should start with, is this the type of content you can be copywriting?
Shall I? Or Alejandro?
Alejandro, would you like to go in?
That's a good question. Educational material, if it is something that you are creating from scratch, that is not elsewhere, then my answer would be yes. And this is the thing that we are looking at, right? That we are developing an AI adoption program in VolueEdge.
If I may, I can add to that. Yes, it's copyrighted material. You have to remember that copyright is automatic upon creation. Once it's on a tangible support, either electronically or on paper. And because it's automatic, you don't have to file for registration. You just indicate the circle C for copyright, your name or your business name, the year of production, and always add something like all rights reserved. So then you're telling the world it's your own material. If they want to copy, they need your permission. Having the official registration by SIPO will add a, I would call it a litigation tool, in the sense that, let's say, Alejandro, sorry, you'll be the bad guy in my story, but let's say I create
Go
this
ahead.
material and I don't register, but I just say, oh, it's okay, like whatever. But then Alejandro starts copying and using it and making money out of it, and we go into court. I don't have my certificate. I will have to demonstrate I'm the creator. If I do have that certificate, Alejandro will have to prove he's the creator. So I always suggest my clients, if it's whatever material you're creating, if it's a sculpture you're making, if it's a book you're writing, a content you're developing, have steps by step, like have phases. Take pictures of your sculpture as you go through the creating process. Have version 1, version 2, version 3 of your book. So at least if anyone copies it, you have proved that you're the creator. And there's a myth that say, hey, but I can mail it in an envelope and send it to myself and never open the envelope. It's a myth. It won't help you in court. What will help you in court is that certificate from SIPO, and I would say the proof that you say, hey, I'm the creator. For 3 years, I've been writing that book. So again, you have step by steps.
If I may just go back to this, just to say if I clearly understood, like you don't copyright it because it's copyrighted as soon as you created it. But
Exactly.
in order to do so, in order to prove it, is like we go back to the suggestion we did at the beginning. Is like you need to plan well your journey that you will be working on.
Exactly.
You will be documenting it.
Exactly.
Saving it somewhere so you can prove it later if needed.
Exactly. And I saw someone that said, what about codes? I'm not a specialist in computer science and code development, but what I've heard through the years I've been with SIPO is, again, like document your source code building. And someone even say you can insert funny sentences in your code that have no impact in running the code, but will say, hey, they can't copy that full sentence. You know, this is crazy. So at least you can demonstrate that it's your own code.
Brilliant. Thank you so much. It's a good one.
I even heard someone say, I wrote something like the monkey's eating a banana in the code and had no impact in running the code, but hey, who would think of that, you know?
Yeah, absolutely. Just easily identifiable. And both Funmi and John have asked sort of a similar question, and they're asking about how copyright and I guess the other protections, how they relate to when you register in Canada. If you then take your business international, is it covered worldwide? Is there other filings you need to do, or is it kind of one and done that you are covered internationally?
I'll start with some elements and then please jump in, Monica and Alejandro. When let's say your copyright, registered or not, is automatic upon creation and currently covers you in 156 countries. Because the costs are so minimal, what I suggest my clients, again, I don't ask them to do so, but I say, register your copyright in Canada. Let's say it's a training document. It's I don't know, training in all kinds of field, and you're starting to conduct business in France or in the States or any other country. And that's a copyright lawyer who told me that a few years ago, so I'm pretty at ease to mention this. Let's say you're doing great business in France. Protect that copyright in France as well. So if ever there's any litigation on that copyright, you will defend it in France. So the court of France will recognize that official registration in their own jurisdiction.
Alejandro, Monica. Yeah, Monica, please.
So I would say from the patent perspective, it's jurisdiction based. It's provisionals fall under a worldwide treaty, which means that if you file your innovation through the provisional, you get 18 months where not only is it not disclosed publicly, but also you have the opportunity in that 18 months to decide where you want to move on for filing a patent. And that is really very useful. So in the long term, you might end up paying a little bit more by going the route of a provisional, but you can have much better sight on which jurisdictions you do need to file in. Patents do get expensive, and the patent costs that were mentioned, I think, were just for Canada. That does not cover Europe. That does not cover the US. That does not cover any of the Asian markets. And all of those markets will vary in importance depending on what market you want to go into.
Exactly.
Trade secrets are free. But
Exactly.
again, if somebody discloses it without your consent, or if you accidentally disclose it without really thinking about it, or getting an NDA ahead of time, it can end up being costly as well.
And just to build on what Monika said, typically entrepreneurs, innovators will file provisional in the States, which gives them 1 more year to complete. And then we'll look at the PCT, Patent Corporation Application, where they have access to 144 countries. And it gives another 12 months to 15 months, depending on the country, to analyze those markets. So like, you may start with 50 countries of interest, and then you say, you know what, I don't have a market, I don't have business partners, I don't have, may not have clients. So I'll reduce my strategy to 10 countries, 15 countries.
Excellent, thank you. And Alejandro, can I ask you, I'll ask you first, but of course we could open it up to everyone. If an entrepreneur discovers that someone is infringing on their IP or their copyright or a component of their IP, are there any immediate first steps that they should take and any resources that are available to them in Canada to address such a situation?
Okay. Yes, I can add a thought about it, but later after perhaps Caroline or Monika can add to it. The first step that I believe is encouraged, and now once again from the perspective of an entrepreneur, is to let know the other party what they're doing, to let them know that, hey, you're infringing on this patent or this thing that I do have, which I own. I'm not sure if in business it is so usual or not, but it exists. That people will want to profit from something else that they didn't do. But some others, there might be some legitimate cases in which they don't, or perhaps you have a perception that they have, but they haven't, and because it's similar. So I think that the first option is first. I think is a letter that you send, Caroline, to cease and desist, to say, hey, you're infringing on this, please desist.
Well, yes, absolutely. But I would say first, it's important to notify that infringement ASAP. Like as soon as you notify, you've noticed that you've been infringed. Importance of networks internationally, if you're having patents, trademarks, and digital designs in other countries. So you have people monitoring your IP there. But the day you notice, yes, please, you can start with direct negotiation because you never know if they use your technologies because they need it. If they use your brand is because they like it. So before litigations, try to negotiate. And if that doesn't work, yes, cease and desist, and it go up to litigation, and it go into long, tedious, lengthy, costly litigation in court. But yes, try to negotiate first, and cease and desist letter most of the time will do the job. But maybe I can say something very, very important right now. There is a lot of scam letters that our clients receive, and they are becoming better and better every day. They're using AI actually, and it really looks like SIPO has sent a letter to some trademark holders or patent holders claiming infringement. So I'm really want to take this space because it's very important. When in doubt, please contact SIPO and verify if this is legit or not.
Excellent. That's a great call out. Thank you. Kayla is wondering, in terms of artistic IP, what is suggested protections for things like video, imagery, language arts, and when considering things like commercial collaborations or when creating something with multiple stakeholders?
That would apply. Yeah, go ahead, Monika. Wait, no?
Oh, no. I cannot add to this. My knee-jerk reaction is very much, it sounds like copyright, but I cannot.
Okay, I'll go. If I understood correctly, the question is anything that there's artistic is protected by copyright. When there's multiple creators, the same rule apply. It's life of the authors. So in that case, the surviving authors plus 70 years. And it's having it registered and also having a contract between all the creators is a good idea. But also if you're planning to exploit that and to make money out of it, have that contract and dividing royalties and whatnot. And yeah, I think that would be a good way to start.
Brilliant. Thank you. Anything to add to that, Alejandro?
No, I think that it was very well explained by Caroline. But indeed, I think that that extent applies not only to artistic, because then in other cases you're also collaborating, and in the collaboration you're creating. And sometimes you need to think. I would say once again, and this is just repeating this for myself, and you know, it's clicking as we are talking now in my mind, that when you're starting a collaboration with someone, you need to keep track of how much is proportionally the work you're doing versus the other person, because at a certain moment down the road you will have to think on dividing. This is patentable, okay, or this is copyright, okay, but now thinking about commercializing it, about monetizing this, like how much is going to be for each one of the persons. I bet, correct me if I'm wrong, Caroline, but I believe that would be the same for arts.
Absolutely. Especially when you start making money, you never know how a good friendship could degenerate. So you need to plan for the best, but always expect the worst. And I always tell my clients a contract is there to protect all entities, not only you or only the other person you're working with. So protect yourself, protect everyone that's involved in the project, especially if it's international, because you have different jurisdictions and different legislations.
If I may add, is this racist because sometimes when collaborating is very difficult across the time. Sorry, there's might be some noise. There's some work being done
Okay,
next to me. But when you're working on something together with a person or a couple of people or X number of people, then as the time passes by, you lose track of who said what and who did what, and because one idea, new ideas don't develop just out of thin air. They come because you hear something, because you saw something, because somebody told you something. So you're building up on the idea of somebody else, that's building up on the thought of somebody else, so on and so forth. So it's very hard to track. So, and yes, this can be a cause for divisions, for losing family, for losing friends. So better to plan in advance, better to track it down, better to document it and speak clearly since the beginning, so we can avoid all these problems at the end.
Yeah, thank you. And I noticed we had two different attendees raise their hand. Unfortunately, I'm not able to have you answer a question, or rather ask a question with your microphone. But if you do have a question, if that's why you're raising your hand, please feel free to add it into the Q&A box. We've got just about 5 more minutes for questions. And honestly, we've a lot of the questions that we've had from attendees were similar to ones that we had for in our draft of questions. I guess just to kind of start closing out the conversation, Monika, I'd be curious to know, were there any resources that you use that you found readily available to you when it came to, you know, helping to educate yourself or starting the process, or just navigating the process of protection?
Yeah, so for anyone that's got access to a university, they usually have innovation tech transfer offices where you can probably ask some initial questions without having to pay for legal fees. Those people usually look to transfer patents from the university to other entities like startups. So they have some knowledge, again, not legal necessarily, but some knowledge from experience. I would say there is value in, I don't remember the name of the grant. Caroline, perhaps you'd be more familiar with it, but there was a grant that was offered at one point, maybe just provincial, where you were given the opportunity of strategizing as an IP strategy for your startup and company. And that's a really good time to ask questions that are pertinent to your startup. Go ahead, Caroline.
If you're talking a few years ago in Quebec, it was the Programme du Premier Brevet, which was funded by the provincial government. But I'll go back to what Alejandro mentioned, is the Elevate IP program that's nationwide. And that's the one that goes, actually it's funneled through incubators and accelerators across Canada through those regional entities that we've mentioned. And it's to learn what is IP up until developing your IP strategy.
Yeah, and so those are really useful. Again, having a fundamental understanding. You're not going to be a legal patent lawyer. You don't want to be. That takes up a lot of mind space. But you do want to have a fundamental understanding so that when you go into those meetings to draft those patents or file the trademarks, get your whatever else you need to file with a lawyer, it's always a good idea to have their jargon in the back of your mind so that you're working from the same set of definitions. And that'll save you a lot of cost.
And if I can add to that, something just came to mind, was shared by a patent agent a couple of years ago. First, shop around when you're looking to hire a patent agent or trademark agent. Call a few. It's a business relationship, but they will be handling your babies pretty much. So you need to trust them and have fun with them, but try to work with them forever and ever, because one patent agent said, at first we're really expensive, but then as my client develops new technologies, I know exactly where they're coming from, where they're going to. So within an hour or two, she can draft the patent application. So the costs down the road, costs will be lowered a bit,
One last
bit.
thing
I'm saying a bit.
Yeah. One last thing that I would say is just because someone's a patent lawyer doesn't mean they're a patent lawyer with knowledge in your field. So also shop around to find a patent lawyer that is specific to your scientific field.
Very important. Yes. And I can add to that, because your patent examiner will negotiate with a patent agent. They're both specialists in their field. So hence the ingenuity factor, that's where it's determined.
Brilliant. Thank you so much. Really great piece of advice there in terms of the relationship building. It's not just you contact them, they give it to you, and that's it. I think that's such a great thing, similar to if you have investors like that, that is a marriage right there. So I guess it's
always what I say, it's 20 years minimum. So get ready,
No, great piece of advice. Thank you. All right. So before I ask my final question, I am going to launch our feedback poll just to give our participants plenty of time to answer this. This really gives us a good snapshot of how you enjoyed today's session. Is there anything different we can do? Any other kind of feedback as well that you'd like to provide us for us to ensure that we are supporting you to the best that we can. So closing out our conversation, this is for each of our speakers. One piece of actionable advice you would give to an entrepreneur, and being that this is for underserved, equity deserving entrepreneurs. So maybe it's specific to those communities. So one piece of actionable advice for the entrepreneurs in Canada regarding their IP to ensure that they're building a resilient and valuable business for their future. Alejandro, can I pass to you first?
Thank you very much. Actually, my advice, I think it goes back to the last question that it was asked regarding resources. When you are first-time entrepreneur, and this is addressing for these first-time entrepreneurs, it is easy to not pay attention or to neglect into certain aspects of your journey, because either your lack of knowledge regarding things that are relevant, because of the lack of experience, or because of you having too many things to prioritize is hard. But IP is a point that is extremely important to the development of your technology and your solutions in your company, that you should not neglect it at all. It starts by educating yourself. And incubators, accelerators, normally some entrepreneurs just start doing it by themselves, but incubators, accelerators are there to help those first entrepreneurs, especially those first entrepreneurs. And they have webinars, they have also courses within all the services that they provide, and some of them have the one-on-one coaching by an expert in IP that dedicates at least a couple of hours to let them know and to go through the dossier that they have.
Thank you, Alejandro. Monika.
Yeah, I think I'm going to almost say something very similar to Alejandro. I think I would say that the most important thing that I found in my journey is it really doesn't hurt to ask. People are sometimes very shy, and depending on your background and what kind of culture you came from, sometimes you feel that it's imposing on someone to ask a question or to ask for help. But if they really don't want to, they will either ignore you or say no. It doesn't hurt to say, I have a question, even if you're asking a stranger. And I've noticed from my own personal experiences that there are a lot of entrepreneurs within the ecosystem that if you reach out to them, even cold turkey, they will, if they've got the time, they will give it to you. And again, if they don't respond, then there's no skin off your nose.
Yeah, you're exactly where you were to begin with.
Exactly.
Yeah, yeah. Great. And Caroline.
Love that, and build, and two things. First, from Monika said, learn from other people's mistake before you make those mistakes. But also, it's never too early to think about IP in your business journey. Even though you're not ready yet, learn anyway, because those concepts that we're talking about, you may not need them right away, but maybe down the road you'll need them, and might as well know and think about and plan for the future, and be agile. Best example is any entrepreneurs back in March 2020 were like, hey, we're doing this, we're doing that, and then the pandemic hits. What are we doing? So you have to flip on in French we say flip on a coin, and then you have to be, okay, what am I going to do? Some markets are closed now. What am I doing?
Brilliant.
Yeah,
Thank you.
just to, sorry, I think Caroline touched on a really important part. It's all about the relationship. So just build the relationship with your clients, with your lawyers, and that will pay dividends. You're never not going to be busy.
Thank you so much. So that concludes today's discussion. I honestly feel like we could have spent another hour talking about it. It is such a meaty topic, and there's so much to unravel from it. And so I know there are hopefully some like further discussions that maybe our attendees would like to have with any of our speakers. Please do get in touch. My colleague Sultana will put in the best email that you can reach out to the Startup Canada team, and then we can point you in the right direction. Firstly, Caroline, Monika, and Alejandro, thank you so much for your time today. It takes a lot of energy to show up, to prepare those presentations, and to take us through an hour and a half of content. So thank you so much for your time and expertise today. Really do appreciate it. To our attendees, same goes to you. It also takes a lot of energy and a lot of time out of your day as well. Entrepreneurs are very busy people. So thank you for spending the last hour and a half with us. I really appreciate it. And for the questions, we barely got to the questions that I drafted, and honestly, that's a sign of a really good session to me. So I'm so happy that we were able to answer everyone's questions, and hopefully that means that you kind of got what you came for today, which really is our main goal. And we'll also have to do a final thank you to Pizza Hut and Equal Slice for their generous support with this program and for their commitment to supporting equity deserving entrepreneurs. Our next webinar will be the third webinar of the Startup Canada Equal Slice 2025 program. That will be on September 16th, and it's all about strategic networking. So building purposeful connections for your growth. We'll share the registration link in the chat. And so we'll kind of be talking about the various different types of networking and relationships that you should be building. And obviously this is definitely one of them. So thank you all so much for today. If you haven't already answered the feedback poll, we'll leave this room open. But if you have, you can get on with your day. And to our speakers, thank you so much. You're free to leave the room now. Thank you.
Thank you very much for the opportunity.
Thank you so much. I loved it.
Thank you.
It was lots of fun. Have a good one, everyone.
You too. Bye-bye.
Thank you. Okay, so we'll leave this room open a little bit longer.